Rule 1.17, that's going to be permitted. Let's move on. Now, you can refer clients to another lawyer or another professional pursuant to an arrangement that's not otherwise prohibited under either the State Bar Act or these rules when, one, there's that this reciprocal referral arrangement is not exclusive. And second, that the client is informed of the existence of that arrangement. So we're not really here today talking about fee sharing arrangements. It's not really within the scope of this, this talk, but even if without passage of money, you cannot have, as an attorney, a exclusive referral arrangement with, let's say, a body shop, a chiropractor, or even another lawyer. I mean, sometimes certain practices are synergistic, let's say family law and estate planning. It's much safer to have a series of attorneys that you refer to so that you don't run afoul of this part of Rule 17.2. And then 7.2 goes on in subpart 5 to say you can't give or offer a gift or gratuity to a person having made a recommendation, provided that the gift or gratuity was not offered in consideration of a promise or an understanding that the gift or gratuity would be forthcoming and that more referrals were coming. So how does this play out? Let's imagine you have a good friend at a body shop and you're a personal injury lawyer, and they refer a case to you. Is it okay to stop by and leave off some gift cards or, let's say, a basket of Famous Amos cookies? Totally fine, as long as there's no quid pro quo. Certainly you cannot have any type of either in-kind or monetary referral arrangements with non-attorneys, at least so far, because the State Bar is considering those kind of changes right now. But again, that's kind of outside the scope of what we're talking about today. So let's move on. Now, there are statutes clearly that are going to prohibit capping, which is basically paying non-attorneys for your cases or case leads, and improper referral arrangements. Now, those statutes would be in the State Bar Act starting at section 6150 through 6159. It's very important to be very careful when you're talking about referral arrangements with non-attorneys. But as we just looked at in subpart 5 of Rule 7.2, gifts are fine as long as there's no quid pro quo, there's no percentage. Certainly if, let's say you've been with your hairstylist for the last 20 years and she knows about your practice, and then she sends you somebody who had an accident at work because she knows that you're going to do a great job for them. You certainly can gift her with a gift card or bring her flowers or anything like that. It's fine as long as there's no, again, actual payment or pre-existing arrangement for those kind of favors. So again, if you do have an arrangement with an attorney for referrals, and it's not exclusive, of course, you have to have that arrangement in writing, documented at the time that you enter that either referral or fee sharing arrangement. And that's a different rule than what we're talking about today. That's Rule 1.5.1 of the Rules of Professional Conduct. Let's move on. Now let's look at Rule 7.1, because as we started, even though attorneys are entitled to free speech rights under the First Amendment, we certainly are not entitled to engage in false or misleading advertising. And so Rule 7.1 is the basic rule that deals with communications concerning an attorney's services. And it says in subsection A, a lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. And what did they go on to try to describe? What does it mean, false or misleading? So communication, and here communication isn't limited just to advertising. It's going to be any kind of communication that you put out there. So it's going to be false or misleading if it contains a material misrepresentation of fact or law, or it omits a fact necessary to make the communication considered as a whole not materially misleading. Let's move on. The seminal discipline case on attorney advertising is In re Morse, which came out in 1995. In this case, this hapless attorney had sent out $4 million worth of ads for telling folks that he can homestead and protect their homes for, I think it was so long ago, he was charging only $30 for the homestead. And what he did is he sent them out in envelopes with a little window that you could see through, and the part of the communication that showed identified their lender. So it made an implication that the communication that was in the envelope came from their lender. So it made it more likely for the homeowner to open the envelope. It didn't look like junk mail. And it said, yes, I can do your homestead for $30. But it didn't say that, guess what? Without the homestead, you still have exactly the same protections under the law. And with those $4 million worth of advertising, at the end of the day, it turned out the attorney made less than like $250,000 on those cases. And he faced significant discipline because he had years of pervasive false advertising. I can tell you, having been a state bar prosecutor for nearly 19 years, I probably handled into a proceeding, meaning filed charges against the lawyer involving just false advertising less than 5 times. Ordinarily, advertising cases would also have an aspect of capping, and violation of capping statutes or referral fees with non-lawyers. Those are very serious cases that usually result in, if not disbarment, major actual suspension. My experience is whenever there's a case that involves capping that is going to be prosecuted by the state bar, where there are going to be charges, they're supported, you usually have missing client money as well. And basically, that's the reason why we have the prohibition of attorneys sharing fees with non-lawyers, because that splits the duty of loyalty that's undivided that the attorney owes their client. Because now the attorney has part of an obligation to that non-attorney that they owe money to, or that they're going to have an income stream from. And when an attorney starts abrogating his or her duties to the client, it's not too far afield from allowing non-attorneys to have access to the trust account. And I can tell you horrible situations where the cappers basically run the office and the attorney gets a salary or a draw. And the attorneys that are prey for those kind of non-lawyer cappers are either very, very young lawyers, so they don't know anything better. I had one horrible case where the attorney had gotten his job off of Craigslist during the last recession in, like, I think 2009, and he was disbarred before he hit 1 year as an attorney. It is stipulated to disbarment. The other susceptible type of attorney is someone that has hit a disability, either a drinking problem or some other physical disability, or older attorneys. So they can no longer keep running the practice as they always had. And this non-attorney, they seem to have a sixth sense to know who's imperiled or who's at risk. And they hook up with, as the office manager, those type of law firms, and they end up overtaking the cases, and the attorneys make very little of the money, and they're the ones facing the discipline. So let's move on. Now let's take a look more deeply at what kind of clarity we get from Rule 7.1, which is basically the rule that's going to say we have to avoid false or misleading advertising. First, if you look at the comments, a communication that has an express guarantee of or a warranty of some result is on its face misleading. And they cite here one of the statutes in the State Bar Act, section 6157.2. So express guarantees of results are on their face going to be misleading. So you'll see, if you see competent, a lot of advertising attorneys, it'll say, these results are, you get someone that says, I got, attorney X got me $5 million, and you only see the poor client from the waist up because he's in a wheelchair. They often have, in writing at the bottom of that kind of TV ad statement to the fact that these results are atypical, or you can't rely on these results because this client got this doesn't mean that you're going to be getting that. Taking a look at the next comment, or comment 3, says this rule prohibits truthful statements that are misleading. So a truthful statement is misleading if it omits facts necessary that make the whole communication as a whole not materially misleading. A truthful statement is also misleading if it's presented in a manner that creates a substantial likelihood that it will lead a reasonable person to formulate a specific conclusion about the lawyer's services where there's no actual factual foundation. Really important to recognize a communication that states or implies a no fee is no recovery. It's going to be misleading if it doesn't also disclose whether or not the client will be responsible for litigation costs at the end of that representation. Now, let's move on. Okay, what is a solicitation? And this is Rule 7.3, subsection E. As used in this rule, a solicitation or to solicit refers to an oral or written targeted communication initiated by or on behalf of a lawyer that is directed to a specific person and offers to provide or can reasonably be understood as offering to provide legal services. Okay, so that's a lot of words and it's a big mouthful, but what does that really mean? Let's talk about what it doesn't mean, and that way I think we'll be able to better understand the difference between advertising like the billboard versus a directed solicitation, which is because they are direct solicitation to potentially targeted, susceptible clients. That's why you're allowed, the state bar is allowed to have more of a control over what is allowed for solicitation versus what is allowed for advertising. So let's move on.
Yeah. All right.
Okay.
Yeah, because I could see it here.
A lawyer shall not buy in-person, live telephone, or real-time electronic contact, solicit a professional employment when the significant motive for doing so is the lawyer's pecuniary gain, unless the person is another lawyer. So they figure we're not susceptible because we are doing this all the time. This is our business. Or the lawyer already has a family, close personal or prior professional relationship with the lawyer. And really, this is the direct rule that would prevent what we used to call, or often still call, ambulance chase. People that they follow the ambulance to the hospital and then they have a bunch of business cards, or maybe they pass them out through the paramedics or the EMTs. There you have potential actual clients. It's not an ad.
What does it do it every
It's not the same as leaving a bunch of business cards at a bus stop. This is like actually potential real clients that may have been injured because they're being transported. Now it says in person, so clearly going to the hospital, that's going to be prohibited. Live telephone, like finding out confidential information about who was transported and then directly calling that home when you're able to get the phone number of someone at that house about the accident. That would be prohibited. And it says here, or real-time electronic contact. And that would mean a targeted email or text message to the people that you have some reason to believe were involved in the accident. Now, let me talk a little bit about a new, very, very new area of potential solicitation / advertising, which is when instead of directed to an individual person, there are now and certainly going to be systems that within a particular geographic area, maybe 1 mile, maybe so many feet, whatever, depending on what it is, a broadcast distribution about potential legal services. Is that going to be a solicitation under Rule 7.3? Or is that more like the billboard we saw, which is really only going to be proscribed by Rule 7.2? These are questions that really aren't answered yet because it has some of the feel of real-time electronic contact, because the way that those systems push out the information, it's going to go to those people in that particular area. However, on the other side of that argument, billboards in Northridge aren't made to have much effect on people on the west side. So they're targeted in the sense of geographic. So these are the kind of things that state bars and trial counsel are going to have to grapple with as we get closer, Because as we know, and I know Nikki's going to be talking about this, social media doesn't have to be the billboard. It can be much more targeted to the kind of clients that you're looking for. And so we're going to get the blurring of the lines between what is a solicitation and what is an actual advertisement, which has more leeway, is becoming blurred. So let's move on. Now, under Rule 7.3b, a lawyer shall not solicit professional employment by written, recorded, or electronic communication, or by in-person, telephone, or real-time electronic contact, even if not otherwise prohibited by A, meaning even if it's not false or misleading, if one, the person being solicited has made known to the lawyer, I don't want to be solicited, or two, the solicitation is transmitted in a manner which involves intrusion, coercion, duress, or harassment. And in that second part, which is, first of all, if they're on a no call list, that's easy, right? For sure. That's going to be one. Or if you've already had someone call that particular potential client and they've already said, please don't call me again, that's going to be subpart 1. But subpart 2, which is transmitted in a manner which involves intrusion, coercion, duress, or harassment. I can give you an example of this type of a situation. It was not decided under Rule 7.3 because it predates the adoption of this rule, but it would have been considered under the prior rule of professional conduct involving advertising, Rule 1-400. And that was what precipitated or was the result of the last recession, which is the loan modification cavalcade of cases. And many attorneys got involved with loan modifications. And the only way to make money with loan modification was high volume. And the way to do that was a lot of them were direct ads or direct mail was a big part of the loan modification strategy to get cases. Many of those attorneys would be using insignia of different government entities to make it look like it came from an official source rather than from an ad. Even if the word advertisement was on the envelope or the paper inside, the way that a lot of those direct mailings were identified or created was to create urgency in the minds of people that were distressed homeowners that already couldn't pay their mortgage, and they were given like a lifeline by what looked like an official or at least approved source, because they were using several, like the government entities, insignia. That kind of conduct ran afoul of the advertising rules, as well as many other rules of professional conduct, which got a lot of those loan modification attorneys into hot water. So let's move on. Now, under Rule 7.3c, every written, recorded, or electronic communication from a lawyer soliciting professional employment from a person known to be in need of legal services in a particular manner will include the word advertisement or words of similar import on the outside of the envelope, if any, and at the beginning and end of the recorded or electronic communication, unless the recipient of the communication is a person specified in paragraphs A1 or A2, meaning another lawyer or like a family friend or family member, unless it's apparent from the context that the communication is an ad. So here is where the difference between a solicitation and an ad makes a big difference. And this is where all these new age types of ways to communicate with potential clients really comes into play. Because does it mean that every time you have a frame of your TikTok video, it has to have the word advertisement? What does it mean? Is that a direct solicitation? I would say, actually, I don't have to say it, actually looking at the comments, putting something on the internet alone is going to be almost, unless there are other facts, most likely going to be an advertisement, not a solicitation. So let's move on. Now, under subpart D, notwithstanding the prohibitions in A, a lawyer may participate with a prepaid or group legal service or one of these registered lawyer referral services. And those have basically cooperative advertising. Let's move on. Now, the comments to Rule 7.3 on solicitation are really helpful to guide what's allowed, what's going to be permitted, going into this new world of attorney advertising and the different possibilities. So let's look at comment 1. A lawyer's communication is not a solicitation if it's directed to the general public, such as a billboard, an internet banner advertisement, a website, or a television commercial, or if it's in response to a request for information automatically generated through an internet search. So if you have like a form on your website that captures like contact information, that is not going to transform your website into solicitation. It's not. Let's move on. Now, the 7 series of the rules of professional conduct cover basically all the different types of communications lawyers have with the outside potential clients or others. So Rule 7.4 is going to cover your communications of fields of practice and specialization. This rule actually represents a relaxation of the rules as they used to be under Rule 1-400 and the Board of Trustees special guidelines adopted under to govern attorney advertising. So under A lawyer shall not state that the lawyer is a certified specialist in a particular field unless 1, the lawyer is currently certified as a specialist by the Board of Legal Specialization or any other entity accredited by the state bar to designate specialists pursuant to standards adopted by the Board of Trustees. And 2, the name of the certifying organization is clearly identified in the communication. So this rule basically is if you are a practitioner in an area of practice that has a specialty as adopted through the state bar, you can't call yourself an expert or you can't call yourself a specialist unless you have taken the exam and gotten the approval through the state bar. Nikki is a perfect example of this. Nikki is dual certified specialty by the state bar in both workers' compensation and immigration, and that's fine. So even if someone has practiced in immigration for the last 35 years and has fantastic results, they cannot call themselves a specialist if they haven't sat for the exam, passed it, and gotten certification through the state bar. And here's the relaxation of the prior rule. It says, notwithstanding A, which we just looked at, a lawyer may communicate the fact that what the lawyer does and does not practice in a particular field of law. The lawyer may also communicate that her practice specializes in, is limited to, or is concentrated in a particular field of law, subject to Rule 7.1. So if you take an area of practice which does not have a certified specialty, you can use the word specialist. That's what this basically means, or expert. And there are multiple areas of specialization, but there are vast areas of law that aren't subject to specialization. So that's basically making it clear that you can use that kind of terminology as long as it's not in an area that the state bar has already recognized specialty. So let's move on. Okay. California Rule of Court 9.35 defines a certified specialist as a California attorney who holds a current certificate as a specialist issued by the State Bar of California Board of Legal Specialization. And it says here, or other entity approved by the State Bar to designate specialist. That's probably because there was a big effort a few years ago to destroy that entire board, which was fought back by a lot of groundswell of a lot of attorneys. It shows that the Board of Trustees still does have some interest in hearing from the stakeholders, attorneys, as to these issues. Now, the State Bar established and administers a program for certifying legal specialties and is authorized to certify other entities to certify legal specialists under the rules adopted by the Board of Trustees. And as of now, that is continuing. There are different prescribed areas of specialty. Obviously, workers' compensation is one. Legal malpractice is another, family law, taxation. There's a whole series of requirements for experience in the area before you can even sit for the exam. Now, query, what happens if you've been a certified specialist, you passed the test, and you let your specialization certificate lapse because you didn't do the extra MCLE, or which are required in order to maintain your certified specialty? You have to do even more than the 25 every 3 years of MCLE that the rest of us have to do. Or if you don't pay the proper requirement re-registration fees. If you continue to use the designation certified specialist and you let your specialization lapse, that is most likely going to be false advertising and run afoul of Rule 7.4 as well as 7.1. Let's move on. Now, Rule 7.5 deals with firm names and trade names. Simple. Section A, a lawyer shall not use a firm name, trade name, or other professional designation that violates Rule 7.1. So you can't use as a trade name something as for your law firm, which is either too close to another name of another existing firm that it becomes misleading, or that makes imprint false to the potential public that you're actually part of a government agency. That would be a problem with Rule A, the subpart A. Now, B, a lawyer in private practice shall not use a firm name, trade name, or other professional designation that states or implies a relationship with a government agency or with a public or charitable legal services organization that violates Rule 7.1. Again, you can't falsely imply some kind of sponsorship or relationship with either the government or some other nonprofit. That isn't true. And C says a lawyer shall not state or imply that the lawyer practices in or has a professional relationship with a law firm unless it's a fact. So you can't blank Rome, I just used her as an example. If you just happen to be Robin Blank, because that's who you've been since you were born, it would be really, you'd have to be very careful how you use your name if you end up going to into business in partnership with, let's say, Jerry Rome, because there already is a recognized blank Rome. You have to be very, very careful, even though those are your actual names, as an example, or another Jacoby and Myers, that kind of thing. What about the fact that it's traditional and has been permitted, looking at different ethics opinions, to continue to use the name as part of a law firm on an attorney that is no longer alive? Isn't that somewhat deceptive? There are ethics opinions that say absolutely not, because while that attorney was alive, he was affiliated, or she was affiliated with that law firm. And by having that affiliation, the firm continued, having that lineage from that earlier attorney is supposed to have an imprint of, quality of the firm. So that has been allowed. What happens if it's a partnership and one of the attorneys leaves, and as part of the agreement, they want to keep one of the names of an attorney that's no longer going to be there? That is a problem, or a potential problem, because if it has a false light to, if you've managed to say, let's say Jacoby and Myers, and they're not there, if they were still alive, and one of them decides to go off, open law offices of Nick Jacoby, if Jacoby and Myers wants to keep, obviously, Jacoby and Myers, that would be a problem. That would be running afoul of this. It would have a sense that Jacoby is still part of the law firm. So that's when you might have trouble with these kind of cases. Let's move on. Okay, what about a website? We already looked at the comments with respect to what is a website. A website is an advertisement, it's not a solicitation, as Lise does now. The way that they are, they're not sufficiently interactive to be a solicitation, which is good news for all of us. Because like I said, solicitations can be controlled a lot more than advertising under the First Amendment. Now, although the rules of professional conduct don't state what that website marketing is advertising, there are formal ethics opinions coming out of the State Bar's ethics ethics committee, COPRAC, that address online advertising in general. And it seems like it's an old opinion, which it is. And believe me, the kind of things that are available online and on your phone and by apps were certainly not even in anyone's mind or imagination at the time this ethics opinion was adopted. But basically, the way that the opinion came down is that a website can be akin to a magazine or other print advertising, and it's going to be analyzed just as you would analyze print advertising. But we know already, because we have experience, a website is not much like a magazine, because you don't have any interactive play with the magazine. You might be able to like order the magazine with a tear off, inside, but the more and more sophisticated websites become, they have more video, you can actually click on different pages to have more of an interactive experience. They're becoming more and more closely aligned to solicitation than advertising. And I expect that this is the area of what's going to be concerned going forward. Let's move on. Now, wherever you advertise, and I'm sure almost all practicing attorneys now have some kind of website, I would hope. I'm looking on my desktop. You have to be very careful with testimonials. Testimonials are like gold. They really, really bring in cases, but you have to be very careful when you're looking for that persuasive content for your website or whatever advertising you do. You have to be very careful with testimonials. I often see on Facebook, let's say criminal lawyers that had just come out of the courthouse with their client. And it's like, we got the case dismissed. It gives me pause. I mean, that's great. But I'm wondering, wow, was there a release sign on the way out down the hall into the outside? I mean, that's a dangerous thing to be using images, from a grateful client who orally gives you that approval, and then who knows 6 months later, because once you put something on the internet, it's there forever. And so we get to be very careful with using testimonials or even staged testimonials, where you have very, very happy, satisfied clients talk about how fantastic you are, which of course you're going to have those. You have to be very careful to put the disclaimer, because otherwise, the fact you're using testimonials without that kind of information that makes it complete, which is that's such a fantastic result, partly because it's not typical. That's why it's so fantastic. Knock it out of the park, right? Let's move on. So that's why, especially if you're going to use that kind of persuasive content, testimonials, be very, I would suggest strongly, use disclaimer language. There should be a disclaimer on your website. First of all, it's going to help explain and give expectations of whoever's looking at your site, that you're not creating an attorney-client relationship just by reading my website, right? And that this is just a communication. It's not legal advice. They can't rely on it for legal advice. You're just giving general information, like if they were on Wikipedia or just hunting for things on the internet. And under Rule 7.2, there's no requirement specific that you have to have a disclaimer. But the truth is, a disclaimer may very well be necessary to avoid creating unjustifiable expectations from clients that later on are unhappy about results and looking for something to complain about. Let's go to the next. Now, what about lawyer referral services? The State Bar authorizes lawyer referral services. These registered lawyer referral services are operated by almost every voluntary bar. LACBA has a very big lawyer referral service. So does San Fernando Valley Bar. I'm sure there are many others all across the state. And many of the affinity bars also have lawyer referral services. And they're governed by State Bar Act starting at 6155. Let's move on. The way that lawyer referral services operate, yes, and joint advertising is permitted. Under 6155, this section is not a prohibition against attorneys jointly advertising their services. By doing joint advertising, you don't de facto create a law firm. It's totally permitted. And you see a lot of joint advertising when there are pamphlets or, attorney directories. Like it'll have a directory and it'll have your qualifications and then that kind of a thing. Okay.
Right. Arms up and saying strength. The joint advertising concept is actually gives individual sole practitioners' strength to advertise in a community that is so difficult to advertise in. So that's something everyone should consider.
Absolutely. It's a good idea to like have cooperative relationships and advertising with other local attorneys, because the synergy helps all the attorneys do better. Let's move on. Now, toward the end of last year, a case was making its way through the California courts, and it was pretty much a plain vanilla case. This attorney Jackson had a legal match contract, and he stopped paying his bill. And it went all the way through, and Jackson lost on the underlying case. But he appealed, and he appealed challenging the whole lawyer referral service scheme, stating that what Legal Match was doing with its online platform, and I'm not sure how many of you, most of you probably have been solicited by Legal Match, so I'd be surprised if any attorney that's been around for any length of time hasn't gotten at least 1 or 2 emails or phone calls from them. And I'm not bashing Legal Match at all, don't get me wrong. The point is, it's basically an online platform that helps match attorneys to clients. That clients in that interactive process, they're on the internet, they find themselves on the Legal Match website, and they get, it pops out to them several attorneys, and the attorneys get those leads in order to follow up and hopefully create an attorney-client relationship. Legal Match had been operating in California for like 20 years as this case was making its way through. But First Appellate District Court of Appeal held last year, end of the year, that in fact, Legal Match could not enforce the contract for payment of services against Attorney Jackson because they were operating an unregistered lawyer referral service. That case sent reverberations through attorney ethics all throughout California. And truth be known, bar associations all over California, because one of the ways that LACBA, as an example, and I can say this directly because I'm the incoming chair for the LACBA small firm section, and LACBA operates 4 major service projects: AIDS project, Veterans project. They have a domestic violence clinic that's embedded in mosque, and they also have immigration project. And almost all of the legal services funded through these for the poor through the bar associations, and LACBA is not alone. I'm just using that as an example. They're funded by the monies paid through the registered lawyer referral services. It's a major source of income for bar associations. So the idea that, wow, Legal Match, which has been eating into registered lawyer referral services monies over the many years, and there are many others. Legal Match is just the biggest one. Wow, they're not going to be allowed anymore. And so here, the Supreme Court, I think in March, denied cert on this case, the Jackson versus Legal Match case. And then State Bar goes in May up in San Francisco Superior Court to try to get a temporary restraining order against Legal Match to stop operating in California. And they already put, this is the State Bar Office of Trials, put out basically press release that they were looking at attorneys that had created relationships, basically relationships with an unregistered lawyer referral service as potential discipline cases in California. So this is something that was not just, ho hum, just Legal Match, because every lawyer that had a contract with Legal Match was potentially at risk. What the State Bar didn't do is let the trial judge know that at the same time as they went in for a temporary restraining order, and those of us, you understand that in order to get a restraining order, you have to have, in order to maintain the status quo, it's so dangerous. That's why you have to have immediate relief, that kind of exigency, which is hard to really show within a company that's been in business for 20 years in California. Why rush now, right? That's one of the problems they had. The other State Bar had a problem with the fact that there was an application pending at that point to become a registered lawyer referral service by Legal Match, which they did not disclose in their papers to the trial judge, which very much dismayed the trial judge. And the judge denied the restraining order and denied the preliminary injunction. That case is still pending right now. And the update is that the state bar has now rejected the application of Legal Match to become a registered lawyer referral service as of right now. So even though Legal Match kind of wants to pretzel itself into the requirements of 6155 of the Business and Professions Code, because they don't want to take this battle on, it looks like we're getting into the same battle which led to Bates back in 1977. It's coming with respect, because Business and Professions Code 6155, the idea of the registered lawyer referral service, has the same rationale as the prohibition against lawyers advertising at all. The prohibition to have lawyers advertising at all fell in 1977. And we may right now be on the cusp of whether or not this scheme, which only allows certain registered lawyer referral services to provide that matching opportunity for clients, whether or not that's going to run afoul of the First Amendment and also access to justice, which is a big issue right now. It certainly makes it harder for clients if Legal Match and all the companies like it that are online platforms of matching clients to lawyers or giving leads to attorneys dries up. Let's move on. So really that brings me to the end of my part of this case. And Nikki, let me turn it over to you.
Okay. Well, thank you very much. Thank you very much, Erin. That was very informative. And I know we have some questions that have come in, so we'll hold all those questions to the end. Now I'd like to introduce Nikki Jacobson. And Nikki has been in the Southern California workers' compensation community for many years. And many of you know her as the first and only dual certified legal specialist. I can say that because she is in both immigration and workers' compensation law. She's been a very good friend to Latino Comp and the Southern California legal community in general, has been very involved. She gives on average 2 of these presentations a month, and she gave me her CV. I'm not going to go through all of them. I asked her just to give me a summary, because once I started counting them, I told her that I felt lazy, that I wasn't doing anything. So Nikki is very, very well versed in immigration, workers' comp. She's been doing this ethical and practical social media marketing. We're thankful for having you, Nikki, and I'll turn the time over to you now.
Thank you, John. I'm always honored to speak at any Latino Comp event. Before I begin my ethics and social media presentations, just want to make a quick point. With COVID and everything that's been happening with President Trump's immigration policies, more and more of our clients, especially the Latino community, and Latino Comp being a derivative of the Mexican American Bar Association and everything that they do, we need to take and keep in mind that many of our clients are very negatively affected, more so by COVID and the current policies. And please, please, please take it upon your social media accounts to continue to educate people about undocumented workers being eligible for workers' comp benefits, undocumented workers not fearing immediate deportation if they take proper action, and knowing that there's some benefits outside of the federal system available to them for financial needs that a lot of people are now suffering. And I find that people are still not educating themselves, and we as the attorneys and their advocates should not just be advocating for their workers' comp rights or the immigration rights, but should also take in mind that their families are in need, and more so during this hard period. So I just want to bring that up. I'll get off of my bully pulpit, I promise. First slide, if Chase, you can, thank you. So we are going to consider many issues today, and I've kind of put them into 6 tips, and I'm going to start with manage all your social media accounts. You can go to the next slide, Chase, I'd appreciate it.
Did you see that?
So if by now you don't know that social media is an important aspect of your marketing plan or your advertising budget or anything you do with getting your name out there, please get on board. More and more you will find that just as a 16-year-old and 18-year-old, And instead of going into each social media account to post anything, you post in one place and it posts it for you all across the different channels. So, platforms. With the free account, you can get up to 3 profiles.
Yeah.
So you basically, when you're starting out, you don't need more than a free account with Hootsuite. And you can schedule messages, you have a one user capability. And I can tell you this, if you are a novice to the social media world, do not create accounts with your own personal emails. Do not create accounts with a password that you often use for your own personal accounts. So let's go back one step so that we're all in the same safe place. When you're setting up the accounts, you need to basically find a general account that's just for your social media at the firm. So let's say our website is jlfattorneys.com. We've created an account that is, let's say, accounts@jlfattorneys.com, and 3 people in the office have access to that who we trust, so that they're able to help us and do the posting with us. I wouldn't recommend when you're first starting out giving this to someone to do until you know you're doing it ethically and meeting all the requirements and the guidelines, because it could go bad really quick and you don't want that. So you've created the account. Even the Hootsuite account should be with a general office account, email, and password, nothing personal, and make sure you do that. Next. So why do I recommend a professional account? For about $300 a year. It's a good investment. You get a lot more out of Hootsuite, and it is very time. It makes it life a lot easier for a month, a week planning of social media. And by that, I mean, look at all the things you get under the paid plan versus the prior slide that we saw. You can do a lot of things in maybe dedicating an hour or 2 a week, or an hour or 2 a month even, and planning your social media posts and automating it for you, so you don't have to think about social media on a daily basis. And a lot of people don't understand, well, what do you mean we can do it all of it in one sitting? Well, that's what Hootsuite does, where you automate your publication. You say, I want to post every Monday, I want to post every Friday evening, whatever. You tell it what you want it to post, and it posts for you, and you don't even have to worry about it. I have a friend, she's a family law attorney. She does her posts for the entire month, in the beginning of the month, and it's done. And she doesn't have to worry about it unless there's some big breaking news or something like that, then she posts. But it's still all done, and you never have to worry about it. Next slide. We keep talking about posts and social media. What to post? Well, anything relevant to your clients and potential new clients. So being a workers' comp attorney, you should be posting about injuries, telemedicine. Right now, telemedicine is a big deal, and a lot of our clients don't know what it is. And so we need to be, in order to get notoriety in an area of law, you need to educate people. And I don't know about you guys, my clients are not very gung-ho about telemedicine right now with COVID, and explaining the process and why it's necessary to move along the case and why they need to be able to get paid their disability payments makes sense to them after I've explained it. So you need to think about what kind of questions are my clients and potential clients asking me right off the bat when I'm consulting with them. So you're always having that in the back of your mind. And you also want to show anything that shows your expertise. Have you written an article? Have you spoken at an event? Have you, served on a panel? Whatever. You want to also show expertise in what you're doing. But again, don't say you specialize in an area of law when as Aaron just said, when you don't have a specialty or you're not meeting state bar requirements. We see that often, and with the way the pendulum of the state bar is swinging right now, please consider that they're coming after attorneys for even false or misleading, not even, for false and misleading advertising, and including something in the verbiage of your ad can be something misleading. So be careful about that. Now, I see this every single day on social media, and it's just it drives me crazy. If you don't have a written waiver, you cannot post anything about any client on social media. I have an attorney who says, well, I didn't post my client's name, I just posted a picture of us coming out of court. Do you understand that there's a thing called Google search by images, and I could just do a search on your client's face and quickly find out who your client is, and that you have now given up your client's identity? So yes, if you don't have a written waiver, do not disclose anything. Some of you have asked in the past about how do you get the written waiver. When I've consulted with other attorneys and even actually spoken to ethics attorneys about this, you may want to consider it as part of your initial retainer package and explain that to them what they're signing and if they're agreeing to it. If they're not agreeing to it, you automatically need to mark that file and be aware of it. But a written waiver, I mean, if the client walks out and says, oh, let's take a picture, yay, you won for me, that's not giving us permission to do something, because you can't prove that later on, and we're attorneys. So that's the best advice I can tell you in this whole process. The second thing that you need to be aware of that's on this slide that is very important is how to stay on top of news that you get quickly and are able to disseminate. Chase, if you go to the next slide.
Don't need a lot.
So,
maybe like fucking some
Google Alerts. If you don't know how to do this, you need to do it as soon as possible. It's right here on top of the page, google.com/alerts, and you set layman's terms that are important to your clients, important to the area of law, and you say, alert me when there is any article, any case, any issue that has come up about those specific topics. I also use WorkComp Central a lot. The information WorkComp Central disseminates and that we get, that helps us a lot in regards to using information up to what to post. So you want to go through that process. And if you go to the next slide, it's simple as, you go to google.com/alerts, you put in the term, you break it down as to what you want, and you say deliver it to the email address. And as quickly as that information comes up, you get a Google alert, and you're able to, when you're sitting down to do all your posts, be able to post on it. What I do is when I get these alerts, I put it in a special folder that says for social media, and then that way when I sit down to work, I know exactly what's out there and what I need to do, because I have all the different alerts that are available. Okay, next slide. Okay, now, when I keep talking to you about you could automate, it's very simple. Once you're in Hootsuite, and again, you can create a free account, you go to Publisher, and you talk about whatever this topic is, and you put a blurb, you put a picture of your firm or anything that's related to it, and you automate it by saying, I want this posted tomorrow at 10 a.m. Those of us who are a little more savvy, we also know when to post certain things, because there are more people on social media at certain times of the day and things like that. You're going to need to do your homework. Otherwise, you're not going to get the best results from your social media posts. I have to tell you, Again, I have a family law friend of mine. She has, her name is Kelly Reichert Chang. She has grown on TikTok, and she's literally turning business away on TikTok. I know John has become very famous on TikTok because he's getting a name for himself. So you may want to find certain social media platforms that you're realizing clients from. So you need to be aware of that. Next slide. Now, everything you do on social media should somehow come back to your own website. And I don't know if any, again, there are people who probably listen to this going, what the heck is she smoking and what is she talking about? Whatever topic, whatever little blurb you're putting, it should have a link back to your website so that you get numbers to your website and you get people coming onto your website. So that's something that a lot of people don't understand. Linking to CNN is not going to be helpful to you. Linking to some other website is not going to be helpful. Figure out who your domain or website person is and be able to make sure saying, I'm going to post on this, please make sure it's on my website. So again, direct all postings back to your own website. Immigration. Chase, next please. Okay. How do we do this and when do we do this? We all, before this concept of sitting at home waiting to get before a judge to do our hearings, we all would sit in court waiting to hear our case heard. So you need to be able to use your phone, use your downtime, and when you're waiting, when you're at your kids' doctor's appointments, when you're waiting in court, wherever, you need to take notes and ideas and things like that. So utilizing downtime is very important. And again, Hootsuite, you're able to do it off of your computer, iPad, and phone. So you can be anywhere and you can be posting. And you can just go through everything and make sure you your ideas. You know, you could be in court with an attorney and some dispute arises and you're like, oh, wow, I wish my clients knew about this more often. And you post about that. So it's just, it could be quick. It doesn't have to be a 500-word summary. You're just giving guidance to people about issues that are coming up in your day-to-day life as an attorney. Okay, next. Utilize experts if necessary. Now, there are many people who do everything I've talked about and they want to be paid for it. And you could Google it and you could look them up and I'm sure they send you emails all the time saying, let us do your social media. But if you have 1 or 2 hours a week and at home, you don't have to be at the office and are willing to do it, you can do it yourself. But you can hire experts. Those of you who have teenagers or kids around and who are internet savvy, they can be your consultants and they can guide you through this process and they can show you what to do and where to go. So, you know, I have to say I love having a 16-year-old and an 18-year-old because they help me along with this stuff. And you can also hire ghostwriters, and there are many apps for ghostwriters. If you didn't know that, people hire ghostwriters and have someone write an article for them and then post it as their own. So there are avenues available to you to utilize different people. Next. Now, before we get into the Q&A, and I know I have some time, I just want to say that maybe you're not on social media all over the place. You need to figure out which one your clients are more likely to use. If you are looking for maybe 20s and 30s, more people are using Instagram. If you're more 40s and 50s, more people are using Facebook. So you need to see what type of clientele you have. The one good thing about Hootsuite, and I find it that more professionals come through that route, LinkedIn can also be part of your Hootsuite platform. So you can have all of your different social medias. So So you could have, younger people are using Instagram, so that's one component, Facebook, and your professionals via LinkedIn, and that can get all tied in. But you have to be able to know which one is best for your clients. In my opinion, if you're not on social media at all, you should consider at least one and start with that and start building basically a name for yourself with people who, your clients. And you need to also let your clients know you are on social media. They're not going to just go, if they're your clients, they're not going to go looking for you on social media. You need to put it in their head, put a seed in their head. Hey, if you need more information from us, go to our social media pages and at the following and follow us. John, do you have questions?
There are some questions or comments. I have a question here regarding geofencing. Aaron, was that you that were just talking about that, or was that Nikki?
I think so. I think so. We're on that brave new world. Why don't you tell me the question?
And the question says, what if the attorney does it at a hospital?
See? Very clever. You're lawyers for a reason. Looking for that line. I can tell you, in my experience, having seen many lawyers that have crossed that line and had unbelievably unhappy results. If you see a line, turn around the other way. Let's not get so close to that line and intentionally go over it. But that's right. This geofencing is the new thing. So it's like, it's okay. If I'm in, let's say, Northridge, and I'm driving down Reseda Boulevard, there's only so far my billboards can reach, right? Because it's geographic. But that doesn't make it a direct solicitation to everyone driving down Reseda. But now, instead of being a stationary billboard, there's technology that can hit all the phones within, let's say, so many, I don't think miles, but probably yards of a particular place where it emanates these messages. Now, is a message that hits your phone more like an email? Because an email, generally an email to a large distribution list, that's an advertisement. It's not a solicitation. Text messages targeted to people that all just got a notice of default. Email, ad, directed to text messages, solicitation. Is the geofencing more like the targeted text messages? I would say yes. And this is an area that literally is right now developing. And when Nikki said this is not the time to be the test case before the state bar, I am not wrong. I mean, she is right. You do not want to be that today, because in the name of public protection, which I have never been against public protection, having investigated and prosecuted attorney misconduct cases for almost 19 years. And the state bar always has been about protecting clients. So that is not I am not against that. But in the name of public protection, the state bar takes as facts what a complaining witness says, even at a lot of times when all the documentary evidence shows otherwise. And how do I know that? Because in 2018, which was the very last year, stats could be run based on the state bar court stats on their website. More than fully 22% of the cases filed against California lawyers that resulted in the merits, not meaning they were based because the attorney died or he just was disbarred in some other case or resigned, but on the merits, fully 22% of the cases were dismissed, meaning every charge was found to be not met by clear and convincing evidence. But even a win is a loss for people. I mean, honestly, think about how much it costs to get there. And that number doesn't include the many, many, many cases where trial counsel says, I want 90 days actual, and the case is really a reproval case. So in order to get your reproval, you're going to have disciplinary costs of about $20,000 if you went to a multi-day trial. And that's just with no discretion. The court has to impose those. So you don't want to be a test case today. So I don't know how the geofencing is going to come out, but if you're geofencing right outside the emergency room where all the ambulances are coming in, I would say that's getting a lot closer to direct solicitation. That's just a very, very effective capper, right? They're now the electronic capper. And capping is very dangerous. I mean, for lawyers' careers.
I have two issues that I want to hit on, the geofencing. Be careful. Geofencing is okay if you're doing a zip code, but if you're doing specific buildings, like geofencing to a courthouse or geofencing to a hospital, I would walk a very fine line with, I would stay away from that as much as possible. Again, you would be a test case. The other thing that I want to talk about that kind of based on what Erin was saying is, do not, for any reason, reply to your clients' reviews, Google reviews, Yelp reviews, anything like that. If you do, you are violating attorney-client privilege, and you cannot do that. If a client goes and says she's the worst person and posts it, they can do that, but you can't go and comment back on theirs and say something on any online review, because you are now violating attorney-client privilege, and that's going to be the biggest boo-boo. I see that where I actually see it, someone saying something, and I'll send them an email saying, get that down as soon as possible. That's violating attorney-client privilege. Do not respond to online reviews.
What if it's just to follow up on that? What if it's a good review? Can you say, thank you for the review?
Correct. You can, as long as you're not disclosing facts about the case. Usually what happens with the bad reviews is that they'll come and say, he never calls me back, or he thinks, or something bad. And the attorney will come and say, well, we never had your information, or they'll try to minimize the issue online. Don't do that. If it's a good review, I always go back and thank them and saying, we look forward to working with you, and da da da. That's not a problem. But factual responses to things that the client had said in the review is a violation of attorney-client privilege.
We have some more questions here, so let me get through them. It says here, I think it's a little bit of what we're talking about. What about client review posting on a website without identifying client? Can you do that?
It's dangerous.
Okay, go ahead, Rose.
I was gonna say, it's very dangerous. I think what Nikki said, even if it turns out what you would put in your rebuttal to, let's say, a bad review is not specifically covered by privilege, because it's, let's imagine, this is actually a real case, so this is not just hypothetical. Let's imagine as part of your response to like really put in context the crazy client's review of you, you disclose the fact that there actually were a felon from like 20 years ago. And by the way, if you're a felon from 20 years ago, that's not confidential, because it's out there. But it's out there, but it's not obvious, it's not up on the top of anyone's mind. So even disclosing publicly available information to put your client in false light can lead to discipline. So this is the term the other cheek crime. It is. If you know, that is to be the professional taking the high road when you have the crazy client. Don't let them trigger some kind of spur of the moment response that's going to be affecting your career for the next 20, 30 years.
And I have
Public
to say,
discipline doesn't disappear.
yeah, and I have to say something on that too. Before you even consider doing a public response, really consider addressing the client's issues privately. And a lot of people don't even take it upon themselves to do that. And on last 2 weeks ago, when my father had passed away, on the day of the funeral, I get a 1-star review on Yelp saying that she was supposed to call me today and she didn't call me back today. This is a true story from the thing. I just sent a email to the client saying, I'm sorry I did not call you back. I just want to let you know the reason for my not responding to you today or calling you today was I was at my father's funeral. And I left it at that. He or she responded saying, I'm so sorry. They took down the review and it was over. So sometimes your clients can be addressed privately for that matter to be resolved instead of, which you can't do publicly.
I have
Can I add on one thing about that? I just want to add one thing about that. Be very careful, because there are savvy clients that try to get discounts by threatening like bad Yelp reviews, right? You're not shocked to know. You never, ever make a deal with the client to either withdraw a bar complaint or not cooperate with the bar in order to get some effect, oh, take, you know what I'm saying? That is separately disciplinable, and I've seen, unfortunately, more than a few lawyers put that in writing, and then guess what? That letter goes to the bar, and that's an easy case to prove. They'll be very careful.
This next question comes from Julie Hogan. I'm going to treat it as a two-part question. Regarding social media, part A, how do you measure results? In other words, how much tracking do you do? Is LinkedIn important? And if so, who is this LinkedIn audience? So it's a multi-part question, but do you need me to repeat it? How do you measure?
Each of the platforms have different components where you can see who's gone onto your on the actual post and how many people it attracted and who liked it or didn't like it, especially the paid posts. And we haven't even touched that. If you do any paid posts, they will send you reports of what age group liked your post more, which area in Southern California liked it. So each of the different platforms has reporting that you can look at. For LinkedIn, I don't find, when I say professionals, I find professionals looking for other professionals to refer are more likely to go to LinkedIn, or someone who's a professional themselves and is looking for an attorney, they may go through LinkedIn. If you're looking at like a normal social media posts, LinkedIn would not be the one that I would say to go for. The one that's more utilized and more family friendly are things like Facebook, Instagram that you should be using. LinkedIn has all of these. Twitter, LinkedIn, Facebook, Instagram have paid components for each of your posts that you can consider also, and the reporting is extensive. But you need to actually do an internal audit on your own clientele and say, okay, I have this many clients from this industry, this many clients in this age group, so you know who you are going after and who your target audience is. And as I said, you need to do some, before you do any of this, you need to do some self-audits.
Yeah, I would add to that. I know I do a lot of social media. LinkedIn would not be something that I would be using to attract clients per se. I mean, LinkedIn, I usually get people trying to market me to help them with projects, or other professionals reaching out to other professionals, perhaps for referrals or whatnot. I've gotten those contacts through there. So I agree with you, Nikki. Here's a great question also. Is it ethical to incentivize prior clients to leave reviews?
It depends on, well, I don't think there's any ethical state bar violation by sending in your closing letter, I'm going to step back. In my closing letter, we send a letter saying, thank you for us. This is what your case is now closed. This was the outcome of your case. We hope you were happy with our services. Please know you can find, if you want to share your information with I don't even know what word we use in the letter. If you're happy with our services, these are the links you can go to leave a comment for us and share it with the world. We say something like that in our letter. When I showed this letter years ago to several ethics attorneys, there was nothing against it. However, be careful, because each of the platforms has their own policy about asking for reviews. And those platforms may not allow you, if they know you've asked someone to do it, will not allow those reviews. So like Yelp, you're not allowed to request, specifically request reviews in like that kind of, for Yelp, because they want their users to be this people who are going forward.
Well, I guess how I understood the question, Nikki, though, is can you incentivize it? In other words, can you say, hey, we'll do X for you if you leave us a review? We'll send you a gift card, or we'll send you, we'll send you a $25 gift card for leaving us a review.
One, I wouldn't do that, because if it comes out in the world that I have to pay for my reviews, I would never want that amongst my colleagues that, oh, I have to do. Personally, that's what I'm saying. But as to the ethical component, Aaron, what do you think? Do you think paying someone for reviews is a good thing?
No, because then that's going to be inherently misleading because you're basically, again, you're paying consideration for review. So what's the likelihood it's actually genuine? So I think Nikki's approach is very good at the conclusion of a happy ending, giving people an opportunity to say, and I don't know that I would say if you were happy with my services. So I think you have to just say, here are the, right? You just say, here are the links. So, you know, I would appreciate a review. It's never.
Share your experience with our firm. That's
Right.
those are the exact words. We don't say happy or not unhappy. We say,
Right.
if you'd like to share your experience with our firm, please go to the following links. Those were the words that the attorney approved.
Exactly.
One last question here before we close up. Just clarifying, the question is clarifying on rule 7.3. Is it ethical, to clarify, is it ethical then to contact a family member or a close friend of whom you know would benefit from your services to give them your services?
If you have the pre-existing relationship, yeah, that's fine. It's kind of like sex with clients. If they're already a partner before they become a client, no problem. But now it's never if they're a current client. So same kind of thing with solicitations.
Okay. All right. I think it's 1:30 now. We want to thank there's no more questions that I see here other than the ones that were answered. Thank you very much, Aaron and Nikki, for all that information. It was great. A reminder to all our participants, if you have not downloaded the handout, it is still available in your GoToWebinar control panel under the section handout. Just click on the arrow and you will see a PDF file labeled Latino Comp July 2020. We want to thank again our featured sponsor, Matrix Document Imaging, and also our sponsors, Gemini and Diversified Vocational, for allowing us and working with us on putting on this educational event. And you have all of Aaron's contact information there on the screen now. On the slide, it's also in the handout, as well as Nikki. And I know that Erin has made herself available to answer your ethics questions. And hopefully you won't ever need to actually hire her. But if you need somebody, she's available and she's in Pasadena. So that being said, Chase, I think we're ready to end the program.
Excellent. Thank you, John.
Thank you.
Okay, everybody.